As senior mentioned in morning that there is a
हाँ.
prevalment and delay.
Yes. They are making some prayer to get it adjourned. जी क्या? Is it contested or non-contested?
Well, it is contested, very highly contested. The reason was that there was an arbitration award already between the parties, which was set aside by the Section 34 court on a remand by the Honorable Supreme Court. My lords would see the title, sir. ये वही MSP judgment है जिसमें Honorable Justice Bobde Saab had given that ruling that section, if along with the statement of defense, the objection regarding jurisdiction is not raised, it cannot be raised subsequently, which came to be overruled in LG Chaudhary 2. So this is that same parties have been fighting since 2002. So it is highly contested. There will be arguments from both the sides as regards appointment. We are effectively, since our award was set aside on a
technical award by the Madhyastham.
No. The award was by the Indian Council of Arbitration as it then stood, and because the clause in
the works contract.
Yes, Mullah.
This is a works contract.
It is a works contract, but as regards the aspect of jurisdiction, this was never challenged. And the award in question came before the amendment made in 2017.
What happened to the earlier award?
The earlier award was set aside on a technicality saying that...
now there is no award.
There is no award.
So now you have to go to Madhyastha.
But as far as the aspect of jurisdiction is concerned, Mullah, that has already been put to rest in the MSP judgment between the same parties, that this objection as regards jurisdiction will not be raised between the parties.
But when we are appointing fresh arbitrator, then...
We'll advance arguments on that. उसमें थोड़ा सा technicality है because this was after a remand from the Honorable Supreme Court.
So it is not never to be decided.
No. It has to
decided in the manner suggested by you.
No. Absolutely not. In light of the decision of the Honorable Supreme Court, that's what I say.
So if the Supreme Court's decision binds the parties,
yes,
then why the Supreme Court remanded?
That is for my lords to consider. They could have decided it themselves, but
you cannot say that Supreme Court has remanded, so we have to pass in accordance.
Absolutely, that's my submission, That is my submission.
The council for.
Should kindly fix a date for this matter.
कब चाहते हैं?
On 31st of March.
31st March would be too early. 6th April.
We commence in 6th of April.
Yes, we list in the at request of counsel for respondent, list in the week commencing 6/4/26.
My lords, I'm grateful.
My lord, I am appearing on behalf of respondent number 1 and 2, my lord. The arguing counsel is adjusted today. I am praying for any date in the next week.
Trial held up?
It's held up.
Your respondent?
Respondent number 1 and 2.
Please लिखिए.
In favor of the other, my lord, the matter is being adjourned thrice, my lord.
Thrice?
Yes.
No, not on our request, my lord. It is for the first time I am praying that too on the adjustment note.
There is a stay. This suit was instituted in 2017. Well, date evidence is not started.
Today, madam, they are adjusted.
So, Marie did given my lord and all under the same head top of the.
Yes, इसमें लिखिए. On account of adjustment note of counsel for respondent number 1 and 2. Case is adjourned. List in the next week under the same head.
reply file किया last day से, but उन्होंने पुरानी email ID में इंसान सर्टी भेज दिया वो.
तो आप लोग आपस में करिए exchange.
I will supply.
आप इसमें से तो डाउनलोड कर सकते हैं नेक्स्ट वीक मैडम. आप इसमें से डाउनलोड कर सकते हैं. चलिए नेक्स्ट.
आइए कंटिन्यू. In this case now, file the application under part 8.1 PC. PC application required to support. Here channel name is order P1 P number 32. Even last parameter. लास्ट पैरा पेज नंबर 30।
ये तो आपकी साक्ष समाप्त हो चुकी है।
नो सर, मैं माय एप्लीकेशन की फाइल नाउ 5/12/25 और माय एप्लीकेशन की डेट है 5/12/2025 और ये मैं विश्वास डिसमिस अब ऑर्डर शीट में देख रहे सर, वी ऑलरेडी फाइल।
आपने एप्लीकेशन फाइल की 5/12/25 को।
जी सर, 5/12/25 को हमने फाइल की। और सर ऑर्डर शीट देखें, पेज नंबर 104 पर मैंने फाइल की करेक्टली ऑर्डर शीट पर। पेज नंबर 104 पी क्लेम का मेरा सर पेज नंबर 104 डेट देखे सर को 5/12 ऑर्डर शीट 5/12/25। सबसे लास्ट में देखें कि प्रकरण प्रतिवादी क्रमांक 2-3 के साक्षी के शेष प्रति परीक्षण हेतु दिनांक 15/12/25 को पेश। फिर नीचे इसमें कंक्लूजन लिखा है सर, 2 के साक्षी के शेष प्रति परीक्षण एवं आवेदन पत्र के जवाब कार्य हेतु 15/12/25 को 15/12 की डेट मिलती है सर। तो 15/12 को फिर पेज नंबर 30 में 16/12 को माय एप्लीकेशन डिसमिस एप्लीकेशन पेंडिंग नाउ बिफोर द कोर्ट बिलो 5/25।
हाँ जैन साहब बताएं क्या क्या।
Not there, two applications have been decided.
हम्म
This order, this P10.
नो दे आर एग्रीड बाय 8/1।
इस पे
8/1 से एग्रीड हैं।
8/1 से agreed है, पर as far as the filing of date is concerned, that application was filed on
8/1 को 13/10 से।
P10,
वो तो सर 13/11 बहुत पहले फाइल कर दी थी, जो सम्मत की थी बहुत पहले फाइल
आइए नंबर 10, 15/12 को फाइल किए ने।
13/11 की 15/13 की उन्होंने सम्मत नहीं किया तो फिर हमने खुद डॉक्यूमेंट फाइल किया 5 मिनट।
ये ऑर्डर शीट देखेंगे पेज नंबर 30 पे।
सर रीजन बस देख लेंगे सर, पेज नंबर 32 जो रीजन क्या देगा
जब-
सर कि नामांकन पंजी में ऐसा कोई
इस
तथ्य
पे-
प्रकट नहीं होता है कि नेसेसरी है। रिपीट ऑर्डर में लिखा है प्रतिवादी जो फैसला प्रस्तुत किया है नामांकन बैंक रिकॉर्ड की क्या उपयोगिता है, ऐसा वर्ड लिखा है सर। 40 लाख का मैंने हमने पेमेंट किया, वो उपयोगिता ना बैंक का मैंने स्टेटमेंट फाइल किया सर। 5 साल मिलती है सर, डेट में हमारे नाम से आया, मैं वो भी केस में फाइल किया, दैट टाइम नॉट अवेलेबल लिखा है। और कोर्ट की
सूद क्या स्पेसिफिक परफॉर्मेंस है। अच्छा अवैध किए जाने शून्य विक्रय पर।
शून्य विक्रय, और that was the documents were in their knowledge since filing of the civil suit. They did not file it. At the fag end, when the evidence was closed, they filed. Prior to that, my lord, kindly have perusal of the order of this honorable court. That is at P5 at page 89. इस पे previously also their right of defense was closed, and they came before this honorable court. And what liberty was granted by this honorable court? Page number 89. पेज नंबर 90 पे पेज नंबर 90 लास्ट में 90 में। Consequently, the trial court is directed to fix the date. Their right of evidence was closed. They came before this honorable court, and very limited liberty was granted to them. Consequently, the trial court is directed to fix one date for evidence of defendant number 2 and 3. And on the date so fixed by the trial court, these defendants shall keep all their witnesses present for examination and cross-examination, and no further time shall be sought by the defendant number 2. The court shall not adjourn the matter for deposition, evidence of the witness of the defendant number 2 and 3 on any ground except on the ground of paucity of the time for the court. At that time also, they did not pray for time for filing those documents. And what documents they have filed? Their application is perhaps P10.
This is
81.
P6 13/10
वेरी हाईकोर्ट के ऑर्डर जस्ट फाइल में फाइल हाईकोर्ट का ऑर्डर है 12/11 का, 13/11 को हमने एप्लीकेशन में
ये 13/10 की है, ये इस पे नहीं आर्गुमेंट कर रही है, ये आर्गुमेंट हो रहा है नेक्स्ट
Rupees 1,000 received on phone pay.
documents were filed page 93. What documents they sought to file? That one statement, that bank statement of year 2012. And that was in their knowledge since filing of the civil suit. And what they say, they got the documents on 1/12/2025. Therefore, no reason for delay has been explained. In the written statement itself, they pleaded the same कि उसमें पैसा हमने दिया था बैंक से और बैंक से पैसा हमने कैश से निकाल के इनको दे दिया मतलब since 2012 they had knowledge of the facts, but they did not get the copy from the bank. And order 8 rule 1A provides for
Mr. Tony, Mr. Saxena, you are for whom?
23, 24 and 25, my lord. Though, my lord, we are formal, but the reason which has been assigned for two documents, as far as khasra is concerned, that has already been exhibited. So there is no necessity under order 8 rule 1 for filing the khasra because it was already exhibited the same. Now, as far as bank statement is concerned, the finding is that what is the reason this is not
approach in this regard would frustrate the purpose for which the provision of code of civil procedure code are amended.
ठीक है, पास ऑर्डर दीदी ठीक है, पास ऑर्डर next.
Well, this is an application for appointment of arbitrator. My lord, I was awarded a contract for running a CT and MRI facility in the hospital premise of the respondent.
What is your objection?
I have two objections in this matter. Number one, my lords, 10.6 says appointment of arbitrator. Before that, my lords, it is a mandatory prerequisite that conciliation is required to be taken place before both the authorities. Number two, my lords, it is a work contract act, so it would be governed by the Adhinima of 1983.
How it is a work contract?
My lords, that could be seen. My lords may have it on page 35.
Annexure A1.
My lords, Annexure A1. That is the introductory part of the RFP. My lords, may I read it?
How it is a works contract?
No, if I may, I read it for.
Set up, operate, and manage CT machine, MRI machine.
No, let's.
It is an
So it's simply
outsourcing contract.
setting up and running diagnostic centers.
It is not limited to that, Millets. The department would provide them a space. They are required to construct it as per the requirements of obtaining the CT scan.
Set up, operate, and manage.
Millets, if Millets may further read it, Millets, may I read it for a moment? It is intended to set up, operate, and manage maintenance CT scan and MRI diagnostic facility for the patient of Elite Hospital of GMC. For setting up this facility, the GMC Bhopal will provide constructed building as is various bases in the Hamidia Hospital premises where the service provider will construct, renovate the facility and install, operate, manage, and maintain a 64-slice CT scan and 1.5 Tesla MRI machine for maintaining diagnosis service to the patient. The approximate number of patients referred by the hospital last year is such and such for CT scans, such and such cases, MRI scans respectively. So they are required to construct it as and when required for placing the MRI and CT scan machines. Now, Milords, pursuant to that, Milords, I have referred a judgment of Viva Highway, that is reference number 12. Milords, may I have a para 49 for a moment? Milords. Milords, may I read it? Reverting back to the unamended definition of work contract, it is noteworthy that work contract means an agreement which must be in writing for the execution
Para
of.
12.
Let's para 49. This is reference number 12, Viva Highways versus MPRDC judgment. In the reference column, that I'm reading para 49 of the judgment.
पढ़िए.
Referring back to the unamended definition of work contract, it is noteworthy that the work contract means an agreement which must be in writing for the execution of any work relating to construction, repair or maintenance of any building or superstructure or other entities mentioned in the said definition. In the definition, it is made clear that the others matter relating to execution of any of the said work are also included, full stop, in a considered view. Whether a concession agreement or any agreement by whatever name called is a work contract or not will depend whether essential ingredients of work contract are available in the said agreement. The essential ingredient in the definition of work contract are the agreement must be in writing. It must be for the execution of any work relating to construction, repair or maintenance of any building, superstructure or other entities mentioned in the definition. The word any other relating to construction, repair or maintenance are very wide. If any of construction, repair or maintenance is involved, nature of construction, repair or maintenance is immaterial.
This was what case? Concessional. Concession agreement.
Concessional. But with regard to operation of maintenance is construction works, this has been considered.
Concessional agreement is firstly you construct,
Construct,
you
build
operate.
and operate.
then you operate. You take the toll, etc. Whatever you have to take. You take some share, you give some share to the government. That is the concessionaire. Is concessionaire of the government. But here it was not the case of constructing and then letting it out.
But
The agreement was setting up MRI machine. Suppose MRI machine has to be set up in this hall. For a moment. MRI machine may require the height of this hall may be 30 feet. MRI machine may require 22 feet. So rest 8 feet may have to be blocked. MRI machine may be round machine. Hall may be square, rectangular, whatever. So the other area may require some civil work. जिससे कि उसको फिट किया जा सके. वो केवल एक परमिशन है कि आप सिविल वर्क कर सकते हैं फिट करने के लिए जितना रिक्वायर्ड है. हम तो आपको एक बिल्डिंग दे देंगे उसमें आप फिट कर दीजिए उतना सही कंस्ट्रक्शन करना है जितना फिटिंग के लिए जरूरी है. बिल्डिंग कंस्ट्रक्ट करने का तो है नहीं.
बस बिल्डिंग कंस्ट्रक्ट करने का नहीं है, बट ऑल्टरेशन ऑफ वॉल्स इज आल्सो रिक्वायर्ड.
Alteration of works for the purpose of fitment of machines. Because they will have to fit and operate the machine. So whatever renovation is required for fitment of the machines that they will do.
That is what I'm trying to bring this to Malak's knowledge. Since there is a part of construction that is required to be done at their end, therefore Malak, I'm saying this would govern under the Madhyasthani.
Suppose there is some supply contract. In the supply contract, some godown is to be constructed. So does it become a works contract?
That altogether is. If
अगर गुड्स को सप्लाई करना है, वेयर हाउस आपको कंस्ट्रक्ट करना है उसके लिए, उसमें ये होगी या तो आप वेयर हाउस किराए पे लें, नहीं तो अपना कंस्ट्रक्ट कर लें वेयर हाउस. अगर आपको सप्लाई करना है गुड्स की, हमारे वर्क्स के पास वेयर हाउस आपका होना जरूरी है, या तो आप कंस्ट्रक्ट कर लें या रेंट पर ले लें. ये कंस्ट्रक्ट कर लें वेयर हाउस, देन कैन यू से दैट इट्स अ वर्क्स कॉन्ट्रैक्ट? He can construct or rent a warehouse. Here it is, he can construct or renovate the building. For the purpose of fitment of machines. For no other purpose.
So here they are also required to operate and maintain it. Maintenance is also one of
Maintain the machine.
Maintain the machinery.
Machine.
That machine is in consonance with the building perspective where machine has been installed. So it is not just the machine.
Where is the arbitration clause?
This is the arbitration clause is at page number 42. Clause 10.6.
Conciliation has failed. Are you willing to say that you are willing for conciliation?
Because they have not opted for conciliation.
That means it has failed.
Conciliation is
Do you say that you are willing to conciliate?
Ultimately, they are trying to vacate the premise forcefully, and that is when we invoke the arbitration.
Machine is
clause.
going on or machine has been closed?
No, it is going on. There is a status quo order granted by a commercial court. Their entire.
They want to get the premises vacated.
They want to get the premise vacated under the pretext that the tenure of contract is 7 years. However, the tenure of the contract from the very first date, it was extended to 10 years. If I may just take my lord.
That's a different issue.
तो ये 7 years मान के उसको concluded बोल रहे हैं. इन्होंने जो notice हमको send.
How much is your claim?
Malad, I have 6 crore 88 lakhs outstanding amount. And we say that the tenure of the contract is still subsisting. We have more than 2.5 years to perform this contract. It was a contract for 10 years and not 7 years. They are reading the tenure of contract which is provided in the RFP. Ultimately, when the agreement was signed, this term was changed to 10 years. इन्होंने हमको 7 साल की समाप्ति पे एक नोटिस दे दिया कि आपके 7 साल समाप्त होते हैं, आप इसको वेकेट कर दीजिए, हमको यहाँ पे नई बिल्डिंग कंस्ट्रक्ट करनी है. And then they have installed all those machineries to evict me, to break down the building. And that's when we approached this honorable court. In fact, इन्होंने हमको जब notice दिया, we also invited them for conciliation. No response was given to us. इनका section 11 का आप reply देखेंगे, उसमें भी they say that agreement has come to an end. It has been concluded. वहां पे भी इन्होंने हमको conciliation के लिए invite नहीं किया. And there are judgments of the Supreme Court which says where there is no scope for conciliation left between the parties. Then the party should be relegated to arbitration, which is precisely the case of the present applicant.
Because if I may submit here,
Manoj, I am also submitting a list of judgments. In all these series of judgments, the court have categorically held that any such clause in the agreement where conciliation is provided, it is not a mandatory condition, it is only directory, because conciliation can also be done by during the process of arbitration. And
Which
also,
judgment? Which judgment?
Well, the first judgment is Demerara Distilleries, paragraph number 5, page number 3 of this compilation. Of the various contentions advanced by the respondent company to resist the prayer for appointment of arbitrator under 11(6) of the Act, the objection with regard to the applicant being premature, the disputes are not arbitrable, and the proceedings are pending before NCLT. The elaborate correspondences by and between the parties, as brought on record of the present proceedings, would indicate that any attempt at this stage to resolve the dispute by mutual discussion and mediation would be an empty formality. Now, relying upon this decision, several judgments of Delhi High Court are there. The second judgment which I would be referring to is the Visa International versus Continental Resources, paragraph 38. It is at page number 18 of this compilation. The discussion is whether invocation of Article 6 providing for arbitration is premature. It was contended that pre-arbitral condition for amicable settlement of the dispute between the parties has not been exhausted, and therefore the application seeking appointment is premature. From the correspondences exchanged between the parties of the paper book, it is clear that there was no scope for amicable settlement, for both the parties have taken rigid stand making allegations against each other. Then paragraph 39, the portion which has been reproduced. A dispute means there may be a difference of opinion as to the future performance of the contract. For example, one party may be denying that any further performance is due on the ground that the contract has been discharged by repudiation or frustration, or it may be a common ground that the contract is subsisting, but the parties may, in a dispute about whether a particular act would constitute a valid performance or whether one party is entitled to give a particular order or exercise an option in a particular way if the parties stand their ground. In such a situation, a time will come when it is too late for the right view to prevail. One party will irresistibly be in wrong and the serious financial losses is likely to ensue. All this can be prevented if the parties can mount arbitration with sufficient speed to enable them to know the true position under the contract before the term of the performance has actually expired. Now, paragraph 41, it is amply clear from the facts as pleaded, as well as from the exchanges of correspondences between the parties, that there has not been any satisfactory recorded by the parties with respect to their claims. There has been no mutual satisfaction arrived at between the parties as regards to the dispute in hand. The claims are obviously not barred by limitation. It is thus clear that there is a live issue subsisting between the parties requiring its resolution. In the light of the aforesaid, the court has appointed the arbitrator. Now, the third judgment, my lord, which I would be referring to is Ravindra Kumar Verma versus BPTP Limited, which starts from page number 34 of my compilation. Paragraph 7, 8, 10, and 11 are relevant. Whereas I will take my notes to page number 40. I'll be reading from the 4th line. Therefore, if the precondition of mutual discussion is treated as mandatory, valuable rights of getting disputes decided by arbitration will get extinguished, and which is not a position which should be acceptable in law. Any doubt on the aspect as to whether conciliation proceedings are required by arbitration clause are directory or mandatory is removed when we refer to section 77 of the Arbitration and Conciliation Act. Now, for a moment, I may take my lords to section 77 of the Arbitration and Conciliation Act, which talks about resort to arbitral or judicial proceedings. It says the parties shall not initiate during the conciliation proceedings any arbitral or judicial proceedings in respect of a dispute that is the subject matter of the conciliation proceedings, except that a party may initiate arbitral or judicial proceedings where, in his opinion, such proceedings are necessary for preserving his rights.
So the present petition has been filed.
Millards, if I may submit for a moment, Millards.
And as regards to their objection for works contract, I will just quickly take my lords to clause number 7.15, which is at page number 38 of my petition. जो ये स्ट्रक्चर की बात कर रहे हैं वो स्ट्रक्चर क्या किया है 7.14 talks about what is permitted under the agreement. It says that service provider will be authorized to make changes in fittings, cables, etc. as per the requirement of operating equipment with written permission from the hospital administration. And the next clause, structural modification will not be permitted. So the agreement itself says so. And recently I'm referring to one of the decisions which my lord has passed on 10th of February, wherein under an identical case was dealt by my lord, wherein a similar objection was taken, wherein my lord was of the view that such contract will not be a works contract. It was simply an operation and management of a convention center.
Yes, what you were saying?
If Millards may kindly have a perusal of page 36, that is the agreement. Millards, clause 5 says period of contract. That initially period of contract shall be for 7 years from the date of signing the.
We are not deciding the dispute.
Millards, I'm not on that part, Millards. Now, Millards, what they says is that the draft that the agreement was initially for a period of 10 years on page 60, Millards.
That we are not expected to see all this in 11.6.
Millards, if I.
Why you are pointing out to merits of the case?
Millards, kindly. Millards.
They say 10, you say 7, then it's a dispute.
Millards may just have.
अगर आप भी 10 कह देते फिर तो arbitration में भेजने की जरूरत ही नहीं थी.
Millards, if Millards may kindly have a perusal of reference number 9. That is a judgment of Honorable Karnataka High Court, Millards, by the Honorable Chief Justice M.S. Shobha Limited versus Nava Vishwa Shashi Vijaya. Millards may kindly come to para 10. That is page number 8. May I read it? This clear from the material of records that the dispute particularly concerning the Bangalore property has arisen between the parties in relation to the aforesaid work order. A bare perusal of the aforesaid clause make it manifestly clear that the parties have mutually made an arrangement to initiate conciliation to resolve the dispute, and if differences were still left unresolved after the stage of conciliation, the dispute was agreed to be referred to arbitration. 11 part 3 of the 1966 deals with the conciliation. Section 61 provides the application and scope and the party. Thereafter, section 62 speaks about the commencement of conciliation proceedings, which provide that the party initiating conciliation shall send to the other party a written invitation to conciliate under part 3. Briefly identifying the subject of the dispute in the conciliation proceedings shall commence when the other party accepts in writing the invitation of conciliation. In the other party rejects the invitation, then there will be no conciliation proceedings. The conciliator provided guidance as provided under section 67 of the Act 1966, which is to only assess the parties in an independent and impartial manner to reach a conciliatory settlement of their dispute. Under section 73,
I consider that.
Thereafter, para 12, 13, the Honorable Chief Justice has considered the judgment of SPB Co.
Do you need to every time stress on who has passed the judgment? You can simply say Karnataka High Court.
No, it's Karnataka. In para 14 and 15, my lords have considered the judgment of STB Company versus Patel Engineering Limited. And
In fact,
present
all
petition-
these judgments have not taken into consideration section 77 of the.
The present petition has been filed for appointment of arbitrator for the disputes arising between the parties, for adjudication of disputes arising between the parties in relation to contract executed between the petitioner on one side and the respondent on other side for the work of setting up, operation, management and maintenance of CT and MRI diagnostic facilities at Hamidia Hospital associated to Gandhi Medical College, Bhopal. Point. Next. The counsel for the petitioner has submitted that various disputes have arose between the parties in relation to payment to be made to the petitioner under the terms of contract and as to the tenure of the contract, inasmuch as the petitioner contends that the tenure has been extended to 10 years, whereas the respondent has denied such extension to have taken place. And it is the case of respondent that the validity of the contract period is only 7 years, as was initially provided in the contract agreement. Point. Therefore, disputes have arisen which need to be adjudicated by arbitrator, and there is a arbitration clause in the agreement which is in the following terms. Which is the arbitration clause?
it's 10.6.
10.6.
10.6. इसका 10.6 कोट करिएगा. ये है पेज
Page
42
42 and
42 and 43.
Next, per contra, it is contended by counsel for the respondent that though there is a arbitration clause, but it is not a unqualified arbitration clause, but it is qualified by conciliation, because it has been provided that in case of any dispute or difference, the same shall be resolved initially by mutual discussion and conciliation. But in the event of failure, it shall be referred to arbitrator. In the place of arbitration shall be at Bhopal. Point. It is therefore contended that the prerequisite of conciliation under the arbitration clause has not been carried out and the application is premature. Point. Second objection is taken that as per judgment of the Honorable Supreme Court in case of so-and-so versus so-and-so 2018, volume 10, SCC 826, any dispute of any kind concerning works contract of the state government, the jurisdiction would lie only before the tribunal constituted under MP Madhyastham Adhikaran Adhiniyam 1983, and therefore, in the present case, the dispute is a works contract because the clauses of the contract also involve construction activity. Point. Reference is made to following clauses of the agreement. Which clauses?
Yes, that is number 1 on the page. That's introduction clause number 1. Page 35.
By contending that in para 2 of the RFP, which is the introductory clause, the contractor was required to construct and renovate the facility, and construction activity is part and parcel of the agreement. Point. The relevant clause 2 of introductory clause is as under. ये clause 2 है, page 35 पर vote करिएगा. Next, the aforesaid assertion was countered by counsel for the petitioner by stating that it was only such construction which was necessary for fitment of the machines, and the construction is not a construction activity but only such renovation or construction which is necessary for fitment of CT and MRI machines, because clause 7.15 clearly prohibits structural modifications in the building. Point. Clause 7.15 is as under. 7.15 कोट करिएगा, पेज 38 पर है. Point. It is further argued that even as per the terms of contract, the building has to be provided by the medical college. Building provide, they will provide building, where is that? Which is
Under
as per
clause
clause
8.1.
7.1, which is as per clause 7.1 of the agreement of the RFP, which mentions that 2,700 square foot constructed hospital building would be provided with installed fixtures, fittings, etc. And in the said building, the machines would be run. The machines would be fitted and then run. Next. This court has heard the learned counsel for all the parties at length. Next. Firstly, the question as regards the arbitration, as regards the agreement to be a works contract and therefore jurisdiction to lie before the MP Madhyastham Adhikaran is taken up. Point. As per section 2 small I of MP Madhyastham Adhikaran Adhiniyam, works contract 2I में
It's 2D.
2D
2D.
2D
2D is dispute and 2I is works contract. Is the definition of works contract.
That's.
so section 2I EFG 2I है 2I works contract is defined as under. Next. Therefore, essentially the works contract has to be contract for construction work of the nature as mentioned in section 2 bracket में small I. Point. In the present case, from a perusal of the terms of agreement, it is clear that the agreement is basically for setting up operation, management and maintenance of CT and MRI diagnostic facilities at Hamidia Hospital associated to Gandhi Medical College, Bhopal. Point. Therefore, it is not an agreement for construction or maintenance of a building, but it is an agreement for maintenance and operation of CT and MRI center. Point. Clause 2 of the RFP though mentions that the service provider will construct/renovate the facility, but at the same time, clause 7.1 makes it clear that the hospital would provide all the requisite facilities along with the building of 2,700 square feet, which is already constructed building with its fixtures, fittings on as is various basis for running of the CT and MRI center. Point. As per clause 7.15, it is clarified. It is further clarified that no structural modification will be permitted. Next, therefore, it is clear that the only modifications, renovations which were necessary for fitment of the CT and MRI machines in a vacant building to be handed over by the medical college was to take place, and only those necessary civil works which were necessary for fitment of the machines were to be carried out. And the introductory clause is nothing but clarificatory clause that the essential civil works which are required for fitment of the machines would not be done by the medical college, but would be the responsibility of the contractor. Point. Otherwise, it is not a work for construction of a center, but rather it's the work of running for establishment and maintenance of a CT and MRI center. Point. It is natural that if any vacant building is handed over and in the building some machines are to be fitted, then that fitment would require some essential civil work. And merely because some civil work is required for fitting the machines, whereas the agreement is for fitment and running of the said machines, it would not render the agreement to be a works contract, and therefore the objection as to the contract being the works contract and jurisdiction lying before the before the MP arbitration tribunal is discarded. Next. So far as the other issue of there being conciliation clause in the agreement is concerned, the said conciliation clause only provides that upon arising of a dispute or difference, the same shall be resolved initially by mutual discussions and conciliations. Point. The aforesaid clause has to be seen in perspective of Section 77 of Arbitration and Conciliation Act, which is as under. Next, Section 77 only prohibits the parties from initiating any arbitral or judicial proceedings during pendency of conciliation proceedings. Point. The Supreme Court, in the case of so and so versus so and so, reported in 2015 volume 13 SCC 610, has held that any clause providing resolution of disputes by mutual discussions and mediation, etc., would be empty formality once there are serious disputes arising between the parties. Point. It has been held that pair of 5.
Paragraph 5.
It has been held that once a dispute has arisen between the parties, then it is difficult to hold that arbitration clause is not invocable. Point. Next. Further, it has been held. दूसरा कौन सा है? रविंद्र कुमार वर्मा.
Ravindra Kumar Verma, paragraph 7, 8, 9, 10, and 11.
It has been held by Delhi High Court in the case of so and so versus so and so 2014 SCC online Delhi 6602.
Ravindra Kumar Verma is also on the same point, and Abhi Engineering.
It has been held as under इसका पैरा 11 और 12 कोट करिएगा. Third is which engineering?
Abhi Engineering.
Abhi engineering.
Yes. Starts from page number 53 of the compilation. Paragraph 14, 15, and 16 are present.
Further, in case of so-and-so versus so-and-so reported in 2022 SCC Online Delhi 4956. It has been held by the Delhi High Court as under, इसका पैरा 15 कोट करिएगा, 15 and 16.
14, 15, 16.
Next. In the present case, there is admittedly a serious dispute between the parties and dismissal of the application under section 11 would only be relegating the parties to empty formality, because in the entire reply filed before this court, it is not contended by the respondent that it is willing to conciliate the matter with the petitioner. Point, even in the reply to the notice which is placed on record as annexure A2, though objection is taken that conciliation has not taken place, but there is nothing in the said notice that the respondent is willing to sit across the table and conciliate with the petitioner. Point. Therefore, a dispute has arisen between the parties. Next. In view of the aforesaid, this court, then as per the Delhi High Court judgment, conciliation has to be resorted to even during pendency of
It can be done when the occasion will arise, if there is a scope for conciliation.
In view of the aforesaid, this court deems it appropriate to appoint a sole arbitrator for adjudication of disputes arising between the parties. Next, resultantly, the application is allowed. This court proposes to appoint any mutually agreed name.
Justice Sanjay Dwivedi. Justice Sanjay Dwivedi.
भोपाल का है, भोपाल में से
The
किसी को
venue
कर
can be Jabalpur, the seat of arbitration shall remain Bhopal.
आप
Look, the venue is required to be in Bhopal only as per the agreement. So Milords may appoint any sole arbitrator.
venue can be any place, seat will be भोपाल,
Seat will be Bhopal.
seat will be भोपाल, venue तो कुछ भी हो सकता है.
Since both the parties are from Bhopal, venue can be at Bhopal only.
आप कहाँ के भोपाल के?
We are operating from.
भोपाल से किसी को कर देते हैं. Therefore, this court appoints Chief Justice Rohit Arya, formal judge, proposes to appoint formal judge MP High Court as sole arbitrator to adjudicate the dispute between the parties. Next, let necessary consent, disclosure and undertaking of the proposed arbitrator be called, be sought by the Registrar Judicial of this court, list on 7/4 for further orders. Will call for his undertaking and disclosure. 7 April. Chलिए, next.